Returning from Korea, I completed my pre-law studies at Western and enrolled at the University of Kentucky. Following my graduation from law school, I entered the Judge Advocate General's Corps to become a regular Army officer in the Army, and I received that appointment, and subsequently I was released from active duty and returned to Glasgow to practice law. And shortly upon coming to Glasgow, I was approached by my friend Louis B. Nunn about practicing law with him, and I accepted his proposition, and I've been in that spot ever since.
Mr. Rogers.
Yes, sir, and I'd like to thank the Glasgow Electric Plant Board Cable TV Division and WCLU for carrying this on the air, and Mr. Barrickman, you, and the participants in this program. It's a wonderful opportunity for us to be able to reach many hundreds, if not thousands, of voters countywide. I was born here in Glasgow, Kentucky, and attended public schools here in Glasgow, Kentucky. Graduated from Glasgow High School in 1972, attended Murray State University, graduated from Murray State University, attended Chase College of Law, where I graduated with a Juris Doctorate degree in law. I'm married to Christy Wilson. We have 3 children, Melanie, Emily, and Matthew. We attend the Glasgow First Christian Church. I've practiced law here in Glasgow ever since I graduated from law school. First began my law practice here by hanging my shingle out, and have practiced here ever since, and been here about 12 years now. I was in the private practice of law for a number of years, serving as a public defender also in the 43rd Judicial District Public Defender Program. Prior to that, I had been served as a law clerk during law school. Worked through a law clerking program and a legal internship. I began the practice of law here as the private practice, continued in the private practice, and became the assistant county attorney, where I served for 3 years. Then resigned from that position. A year later, became the Barren county attorney. Have served in that position since, and of course am the county attorney now and candidate for re-election.
Since you are now holding the office, perhaps you should tell us the duties of the county attorney.
Well, it's an interesting question. Few people realize that the duties of the county attorney have changed somewhat over the years. The county attorney is a constitutional office and has the duty to prosecute criminal cases in the Barren District Court. By judicial amendment, by legislative amendment, the county attorney became part of the integrated prosecutorial system under the leadership of the Attorney General. And that changed somewhat the format and the administration of the county attorney's office, but most of the duties stayed the same. The county attorney has a duty to prosecute in district court, also a duty to represent all of the county officials, to counsel with and advise the Barren Fiscal Court, and to counsel with many of the county officials and, in some instances, state agencies when called upon. Now, traditionally in Barren County, the county attorney has not been called on that often by state agencies such as the health department or other agencies that by statute he could be, but has served as prosecutor in the Barren District Court, counselor and advisor to the fiscal court and the county officials. And for about the past 15 years it has been the practice for the Barren County attorney to conduct all of the child support services in this county. It is one of the most, I think, important positions in county government from the standpoint of its interaction with the people and the officials. So the county attorney's office has many duties, requires appearances in district court and also circuit court and the Barren Fiscal Court. It requires a great deal of administrative ability as well as prosecutorial ability.
Mr. Travis, do you agree, or do you want to add, or any comments that you have about the duties of the county attorney?
Well, Uhel, I would not particularly disagree, but I would like to draw some clear lines about it. I think without any doubt and beyond a question of doubt, the first and foremost duty of a county attorney is to prosecute the violators of the criminal and penal laws in the district court of this county. That is singularly the most important thing and should not be relegated to assistants to do. Everything else is secondary. Now, there's clearly another division that has to do with advice for which the county attorney is compensated by the county. The state pays for the prosecutorial services under the unified system, and the county pays them for legal advice to for the various boards, commissions, agency, and the physical court, and so forth. And then there's a third that is not a duty, but is provided through a contract, and that is the Child Support Enforcement Division, as most of the offices are handled in Kentucky. I think there are 7 counties that don't do that, and 113 of them that do. And that presents a lot of conflicts with the operation of the county attorney's office.
Do you have anything to add to his comments before I ask you another question?
Well, I do, Mr. Barrickman. The prosecutorial duties are important. However, the responsibility to the people of Barren County in counseling the fiscal court, in counseling the many county officials who require the advice of the county attorney, I think is equally as important. In my first term here as county attorney, I know that there have been many occasions that it's been necessary to counsel with fiscal court, it's been necessary to counsel with county officials, and to represent county officials in legal actions in the courts of the Commonwealth. I also feel that the child support services are equally as important as those other 2 services. This county has historically, traditionally, had a strong child support program. The county attorneys in this county have carried out that function and seen that that was an equally as important function in this county for 2 reasons. It protects many residents of this county, and it recovers thousands of dollars of taxpayer money.
Mr. Travis indicated, and I think correctly, that you would agree that that's done by contract. Perhaps you tell the audience, contract with what or with whom?
Yes, sir. That's a contract with the Cabinet for Human Resources, an agency of the Commonwealth of Kentucky. That is a contractual provision that is provided for by statute. The legislative scheme in providing for child support services requires that. To go a little deeper so that one in the audience might understand it, the federal government funds the Aid for Families with Dependent Children program. Now, in order to fund that for the state, the federal government requires that the states enter into contracts with officials to recover those benefits paid out by taxpayer money. That is, to have some plan or method to recover the benefits paid. The state government is under obligation, in order to participate in the federal Social Security program, to establish such programs. Kentucky has, and has established it according to federal guidelines, part of which, through the legislative scheme, require contracts with county attorneys. Now, my opponent is correct. Not all of the counties participate in that, although by far, as he mentioned, the majority do. The statute provides that the county attorney is to be the person of first right to do that, the person the statute looks to do that. If the county attorney refuses to carry out that statutory duty, then the Commonwealth can contract with private individuals to do that.
We'll get back on that subject a little later about some matters, but you have any comments to make?
Yes, I think Ben just mentioned a very important aspect of it. There is a duty to do that, but if they refuse it, they contract. And what has happened, the county attorneys have found this to be most lucrative, to refuse to do it as part of your duties and then contract for the state and rake in the money from it. And that's what's been going on. The whole program needs to be looked at from the state level and the federal level, and there needs to be some legislation to correct some of these abuses of the system.
But that would be required by the state and the federal government.
Absolutely.
Not locally.
Absolutely.
We've been talking about the various duties. How do you have your office, Mr. Rogers, organized to carry out the duties that you and Mr. Travis have been discussing here?
Mr. Barrickman, the county attorney's office is organized, of course, with me as the chief prosecutor. I have two very competent assistants, Jeff Sharp and Dennis Wilcutt. Now, Jeff Sharp is what the state refers to as a part-time assistant. Mr. Wilcutt is a quarter-time assistant. Then I have Gail Gross as secretary in the office. I have Vicki Alexander and Cheryl Edmonds as secretaries in the office. Now, that's the county attorney's office, and that's located in the courthouse. The child support office is located across the street in the same building that my law office is in. It hasn't always been that way, and your question about the organization of the office, I think hits right on the reason that it hasn't always been that way, and I'd like to explain that, if I may.
Go ahead.
When I began as county attorney, the child support office was located in the county attorney's office. Incredibly enough, Barren County Tax Commission money was being used to operate the child support program. And through use of the state law, legally, the state was paying what amounted to rent to the county attorney's office for the space in the courthouse. Well, the state does not pay Barren County rent for the area that we occupy in the courthouse. And besides that, we were woefully crowded. Women were bringing children in there for these paternity cases, and were just stacked one on top of the other. I think the total space in there was probably less than 200 square feet, which had to be shared with the prosecutorial staff. One of the first things I did was immediately stop using tax commission money to in any way finance the child support program. I then moved the office into an area triple the size at less the cost, because through the use, and I realize this gets into some technical phrases we perhaps can talk about later, but the child support program was operated on what was called an indirect billing program. We changed that to a direct billing process. We're able to save the state money, have additional space. Through the tax money that was saved, we were able to hire additional help in the county attorney's office. And I'm very proud of that, and I think it's just worked wonderfully.
Who pays the two assistants? Is that funded by the state?
Yes and no. Jeff Sharp is an assistant that is funded by the state through the Unified Prosecutorial System's budget. Mr. Wilcutt is paid through the tax commission money, which had previously been going to operate the child support program. So by saving that tax commission money and causing the child support program to operate independently on its own, we were able to funnel that money into additional prosecutorial staff, which, as I'll talk about more in this program, has served the county well.
Now, what do you mean by define for the audience tax commission money?
Tax commission money is money that the county attorney earns for carrying out tax collection duties. Those duties can be as simple as sending out a letter at the request of the county clerk to advise someone that the taxes are delinquent, to litigation, or in cases as we have before, filing proofs of claim in bankruptcy court and representing the county's interest there. It's not at all unusual for the county attorney to receive service of a complaint in the mail or by sheriff, notifying the county attorney that the county's been named as a party in a foreclosure suit, for instance, where taxes are owed. Then we step in and protect the county's interest.
So you're talking about, when you talk about tax commission money, are you talking about fees that you earn as county attorney for collecting them and using them to pay for another assistant, or are you talking about taking the part of the money that you're collecting for the state and the county and using that to pay the assistant? Which is?
No, it's taking money that's paid through the county tax collection process. That money can only be used for operation of the office. The statute defines how it's to be used, and we must use it that way and do.
But you do get a fee as county attorney for it in addition, do you not?
No, sir, not personally as compensation, I do not. It would be unlawful for me to do that. I can only use that money to operate the office.
One final question for you, and then I know Mr. Travis has been sitting over there. His mind's turning, I can tell by looking at him. You'll have your say, Mr. Travis. Equal opportunity here. I want to lay some groundwork. I take it from what you say that your predecessor had only the one assistant.
That's correct.
And that was you, I believe.
That is correct.
Mr. Travis, the floor is yours now for a while.
I don't know what part you want to address, Joe, but I've always found it amazing that public officials have to have 2 or 3 assistants when they're not even full-time themselves in doing their job.
Well, let me phrase the question then. Hey, if you are elected, how are you going to organize the office? And would you organize it similar to him or different? And if different, why? And do you have any criticism of the way he's organized the office?
Uhel, I might give you a little background. When I was in the legislature, I introduced legislation to make the county attorneys full-time prosecutors and prohibit them from engaging in the practice of law, and prohibit them from engaging in any activities that would present a possible conflict. And there are many in the things that they do now as a customary part of their duties. But I was unsuccessful in getting that off the floor of the Senate. I got it out of committee with the help of some very prominent Democrat leaders who recognized the validity of what was going on. And the timing was not suitable later to do that. But yes, I think it's atrocious that we have county attorneys that are receiving the money that they are from these offices, and that they're part-time, and then they hire 2 or 3 assistants to go do their job for them. I think the county attorney should be in the Barren District Court, attending that court and doing his duty, and not have some assistant down there doing that. Now, the assistant they have in the prosecutorial service is paid by the state of Kentucky. It's in the state budget. The last time I looked at that budget, the state sends some $88,000 or more in here per year to Barren County for the county attorney's prosecutorial salary of roughly $39,000 a year, which obviously he's doing something else, but he's taking the money, and then they're paying assistant prosecutors to stay down there and do the work. And then we come up with a third assistant county attorney that I don't know what he does. I've been told that he handles the appeals, and I went over and checked the appeals, and in 1962 there were about 13 or 14 of them.
Well, pardon my interruption, you said the third assistant. I thought he mentioned 2, and I may have missed one.
Well,
Who's the third one?
Well, he got a third one because he filed a Form CS-22 with Child Support Services listing John Rogers as an attorney employed in the county attorney's office at a salary of over $18,000 a year, and it was dated October 1, 1992. So I don't know what they all do or what they're paid off or where it comes from. But I'll be glad to show you the form that he filed with the state of Kentucky to that effect. So I don't know what they all do, but I know that the county attorney should be attending the district court and performing the duties. And there obviously are some things they need assistance for, but that attendance to that court and the prosecution should be the county attorney's first duty. And that is not being done.
If you are elected, how are you going to organize the office?
Well, the first thing I would do if elected, I would withdraw from the private practice of law and be a full-time attorney. I would avoid every possible conflict that you could have with prosecuting the law violators in the Barren District Court. That would be the first thing. There would possibly be one assistant. I would certainly not need Dennis Wilcutt receiving the pay he does, and he's even on the state retirement system for doing what nobody seems to know, nor any other assistant. I think one is, in fact, I know that one is all we need, because I'll be there doing it. I was always surprised when I was Domestic Relations Commissioner seeing Ben up in the Domestic Relations Court on Monday morning when Jeff Sharp was down in the District Court. But I found out later why, because it's the way they're paid by the child support people. They get more money per hour for Ben to be up there than they do for Jeff to be up there or another assistant. And that's, the whole thing is money, and it's a gross conflict of interest the way in which it's handled.
Are you saying that if you are elected that you will be a full-time county attorney and will not engage in the private practice of law? Is that what you're saying?
Mr. Barrickman, I would do what I propose as your state senator for this county and 6 other counties. I would be a full-time county attorney and do the duties of that office and would not engage in any private practice of law, not even write a deed or a mortgage. Because when you do that, you're detracting from your duties and you're well paid. I would like Mr. Rogers to tell the people of Barren County what he takes out of that office each year, including the child support and the cold check fees and the salaries paid by the state of Kentucky and Barren County. No one seems to know. You can't find it anywhere.
Do you care to respond to?
I most certainly do, Mr. Barrickman. I would mostly like to respond on behalf of those dedicated and extremely competent members of my staff and a member of my family, and not so much myself. My brother, John Rogers, has never, ever received a penny from Barren County or from the state of Kentucky. What Mr. Travis refers to is a request I made of the state to allow him to be certified as an attorney permitted to appear in child support cases should the need ever arise for that, if Mr. Sharp would be unable to cover for me or if Mr. Wilcutt would be unable to. Now, the child support services are totally separate from the criminal prosecution services. That's a deliberate decision I made in setting up the office. That's part of what I said I would get back to concerning the organization of the office. Fortunately, I've been able to diligently carry out my duties. I've not had to call on John Rogers to step in and protect the interest of the county should I not be able to, because I've always been able to. On occasions, Mr. Sharp has stepped in for me, as is part of our organizational plan. Now, my opponent refers to Mr. Wilcutt. Mr. Wilcutt has done an extremely competent job. I'm sure if my opponent has thoroughly checked the appeals records, he's seen that we have an outstanding appeal record of the appeals from district court to circuit court. And unfortunately, the majority of these appeals that we see from district court are cases of driving under the influence. Now, many criminal cases are just as important as driving under the influence cases, but of course the danger in a driving under the influence case is that we may have a criminal defendant who still has his driver's license, still on the road, and we'd like to get those cases followed through and have a final judgment on them. He's done an outstanding job. In addition to handling the appellate duties, Mr. Wilcutt has been part of our 24-hour, around-the-clock prosecutorial team. When Mr. Wilcutt and Mr. Sharp and I sat down early on in my administration to discuss a competent, proper way to represent the people of this county and to provide the service to the police and the law enforcement officials, which perhaps we can talk about more in this program, we decided that there was a need to have an on-call system. That is, a system whereby any law enforcement official or any citizen of this county could reach either myself or one of the assistants. We've done that. Just this past weekend, for instance, Mr. Wilcutt, I think, wrote 5 or 6 warrants at the police station after hours. That's not unusual. That's part of what we do. And with a county of this size, with a court system the size of our court system, with the caseload that we have, and we rank as one of the top counties caseload-wise, it's imperative, it's absolutely essential to have competent assistance, to have an organization that can work and cover all of the services. One county attorney cannot do it, and there is no intention that one county attorney be able to do it. And it would be, I think it's a misrepresentation to the people of this county to expect them to believe that one county attorney will be able to successfully handle all of the duties of the county attorney's office.
He's raised 2 questions about the revenue of the office. I gather he's talking about the total revenue that is collected, as well as the revenue and pay to you as county attorney. You want to answer those?
Yes, certainly. The state pays the county attorney for his prosecutorial duties. The county pays the county attorney approximately $14,000 for his duties to the fiscal court, to the county officials, to representing the county in lawsuits within the courts of the Commonwealth. Now, in addition to that, the legislature has set up a system whereby the county attorney has incentive to earn more and to be more productive. It's one of the few county offices where a portion of the income is based upon job performance. Now, Mr. Travis, I think, is right. I could sit back, he could sit back, perform only the prosecutorial duties, only what's required by the county, and draw 2 paychecks, and not draw any other. I've been able to take the child support system, not only make it more efficient, make it operate without Barren County tax money, but also very productive, and I have earned money from that. In addition to that, I have taken the cold check collection program, expanded it to Park City, Cave City, Hiceville, Temple Hill, and communities all through this county that didn't previously have that protection. And we've recovered hundreds of thousands of dollars for Barren County merchants. Now, the county attorney is paid a fee of $5 per check per request letter for recovery of those checks. Now, as my opponent has pointed out, I think in some of his advertisements, a county attorney is allowed to charge $10. We don't do that in this county. We've felt that $5 was adequate. That money, by statute and by direction of my superior in the prosecutorial system, the Attorney General, may be used as personal compensation or as personal compensation and expenses for the office. I've used it for both. I'm proud to say that. I've been able to earn a good living. I reported a gross income of about $105,000 on my taxes. I'm not ashamed of that. I'm not ashamed of that because it represents hard work, improvement to the services of the people of Barren County. Just as I have done well and profited, so have the merchants of Barren County, so have the single mothers, so have the taxpayers for the hundreds of thousands of dollars of tax money recovered by my office. It hasn't always been that way. When I began as county attorney, that money wasn't there in those amounts. And we've worked hard, built a good organization, and they are now. And I'm proud to have participated in that system and have nothing to be ashamed of for it.
Mr. Travis.
Mr. Barrickman, I'd like to address 2 points specifically. And first is the cold check service fee. I happened to talk to the little attorney general who sent Ben his political letter the other day trying to justify his spending that money for personal income. And I asked him what effort he made to determine the intent of the legislature when that act was passed. And he said none. He said there are no records that I can find. I asked him how many senators or representatives have you interviewed about that. He said none. I said, well, you're talking to one now, and I voted for that bill. And I voted for that bill, as did the other senators, for the specific reason that we wanted to help the counties and save them the expense that they were undergoing in sending out the required notice under 514.040 that's required on insufficient fund checks to give them 10 days notice. And I said that was the sole purpose of that legislation being passed, and it was never passed to enhance or increase the income of the county attorneys, but to permit Barren County and all other counties similarly affected to recover their cost in providing that service. And that was the reason. In addition to that, there are numerous statutes and sections of the Constitution that prohibit the use of that money for personal income purposes. They're numerous, and it should not be used. As County Attorney of Barren County, that entire sum of money will go to take care of the expenses of the office. And I might point out that the Barren County budget for the year ending June the 30th, 1992 was slightly over $30,000 for that office. You had almost $20,000, almost $19,000 in 1992 from the cold check fund. That would have been 2/3 of the entire cost of the county of operating that office, and that's where the money should have gone, rather than to the county attorney as personal income. Now, I'd like to mention another aspect of that, and that is in regard to the child support enforcement. My opponent likes to have everyone to believe that he has done great and tremendous work with this organization he's talking about in enhancing child support collection. If anyone bothered to read the forum section of the Courier-Journal on Sunday, they could find out the truth about it. There was a graph printed on the front page of that section showing how child support collections had increased in the state of Kentucky over the last several years particularly, and it also gave you the reason for it. Mike Robinson, the commissioner, stated in that article that the increases were due to legislative action in 1988, and he could have added 1990 as well, because the legislature, and I was one of those who did part of this, imposed wage assignments on persons who owed child support. The one thing I did do when that was imposed, I did not think it should be mandatory immediately in every case, because it should not be a burden on employers and the individuals and should not embarrass them initially. But if they became in arrears 4 weeks, there should be a wage assignment. In 1990, the legislature changed that, and they made that wage assignment mandatory in every case, and the commissioner or the judge has to give a darn good reason for not imposing a wage assignment according to law. At the same time, the child support guidelines were adopted, which greatly enhanced the amount of child support that recipients on AFDC, non-AFDC, and all other persons with children in their custody could receive by way of child support. And this is the reason for the increase, and I just ask anyone who has any doubt about it, go back and look at Sunday's Courier-Journal. It's all spelled out in great detail, and it's exactly my position, and it's been my position all along.
Well, I'll address this question to both of you. Obviously, the two of you are in disagreement as to how the so-called cold check money can be used, whether it can be personal income to the county attorney or whether it belongs to the county or the state. Obviously, this system is being used and is the law in all other counties of the Commonwealth. How are other counties using this money? Who knows?
Mr. Barrickman, at first, there again, let me speak on behalf of someone who's not here to defend themselves. Mr. Ross Carter is not a little attorney general. He is a distinguished gentleman, an experienced attorney, and a longtime member of the attorney general staff in Frankfort, and one of the assistant attorney generals. I've dealt with him on many occasions as county attorney in many matters. I've always found him to be honest, competent, straightforward, and not at all political. Now, as to how other counties are using the money, it varies, I'm sure, from county to county. In this county, we've chosen to use that money, which I could use entirely as personal compensation if I wish to do so, which I do not. I could double it by charging $10 per item, which I do not. And I've used it as both personal compensation for which it may legally be used and as to cover office expenses. There have even been times during the administration of my office that we didn't have enough in the way of tax commission money to be able to meet adequate payroll and pay secretaries and help in the office, because that tax commission money varies from quarter to quarter. I've used that money for that. I didn't lay people off. I didn't cut back on the services to this county. I pulled that money out of there and used it for that. And it didn't bother me a bit to do that.
Do you know how it's used in any other counties, Mr. Travis?
No, I can't state what they do in other counties about it. I differ strenuously with what Ben Rogers said when he says that is legal. He has absolute no authority except that weak letter from the Attorney General's office who said he didn't know what the legislature's intent was. And it's obvious that if the legislature didn't intend for that to be Ben Rogers' slush fund money, that it's taxpayers' money, and he's going to be responsible for it somewhere, sometime before a court of law. And it's obvious that if this has not been resolved, it should be resolved in the future. So I don't accept at all that this is legal. It is illegal. I was one who voted on the legislation, and I clearly understood what it was for. I don't know what others were doing, but let me point out something to you, that you could have a county like Jefferson would have probably, under the old $5 rate, $1 million a year in this money. And are you going to tell me that money belongs to the county attorney? Now, who are we kidding? But then would they apply the constitutional and statutory limits on the compensation of county attorneys? You know, there's a limit on them. And there's a limit on county officials, and there's a limit on different tiers of county attorneys as to what their compensation is. And I submit to you that any time that they take in excess of those constitutional limits, they're in violation of their duties and responsibility to the citizens of Barren County.
Any other comment, Mr. Rogers, before we go to another subject?
Mr. Barrickman, that sounded an awful lot like maybe being challenged to a lawsuit or something, but all I look forward to is the voice of the people on November the 2nd. And I think when people take the time to go back and look at their newspaper, as my opponent has suggested, they'll see that letter from Mr. Ross Carter, and they'll be able to understand that. And I think enough said on that subject.
I might point out one other thing on that Mr. Rogers' predecessor did not use the money the way he's doing it.
What did he do with it?
He used it for office expenses. And in fact, he showed me his entire checkbook. And by the way, Mr. Rogers said he gave me his checks. He gave me his checks because I made an open records request on him for them. And Danny Basil showed me his checkbook when I asked to see it and how he handled it. And he was shocked when he looked at what Ben Rogers was doing with his.
Any other comment?
If I may, Mr. Barrickman, as my opponent well knows, he asked me for those checks. I gave them to him. And it's as simple as that. If he wants to call it an open records request, well, you know, that's the way he terms it. When I was asked, I gave them. Perhaps it would be interesting if Mr. Travis would run copies of Mr. Basil's checks in the newspaper, but I don't really think that's what the voters want to see or hear. I think the voters want to know what we as candidates plan to do to help them. You know, when you hear a politician tell you what he's going to do, look and see what he has done. But in this case, I don't even think we've heard, you know, what my opponent's going to do for the people of Barren County. And I know they can look and see what I have done, and I'm quite proud of the accomplishments that we've made.
Another issue that has been brought to advertisements, to say the least, is your leasing your mother's property. And since the affirmative side of it has been brought to the public's attention by Mr. Travis. I'll let him go first on that, and then your response. Mr. Travis.
Yes, Joel, I appreciate that. As you know, that I occupied for years the space now occupied by Rogers and Sharp and Trial Support Office. And Governor Nunn and I used part of that office for years for $100 a month, and Harry Berry had the part used by the Child Support Office for $50 a month, including the utilities. And then subsequently, Ben moved up and took the part that Harry had, and now that's the Child Support Office, and they're paying $375 a month for it. And I think that is absolutely and utterly outrageous, particularly when if you knew, and he hasn't told you tonight in response to any of your questions, what he's getting from these various entities. He's never told you tonight what he's getting out of child support money. But we know that he's paying $375 a month out for the rent on his office building out of that money. Well, that's all we know, because he hasn't told you anything else, and I think it would be very interesting to find out. That building, the ground floors of the adjacent buildings to that one, including the principal street level building and the basements of the two buildings next door, rent for $325 a month. And they pay an additional $125 months in each one of them on utilities. And here we've got 600 plus square feet up on the second floor in Mr. Rogers' office, where he pays $375 a month, where I rented it for years for $150. The whole building's about 2,000 square feet.
Mr. Rogers.
Yes, Mr. Barrickman, I know that Mrs. Rogers is just proud to have a tenant there that does pay the rent in a timely manner, and I have always, since I have been in that building, which was, I think, about since 1985, paid rent. First to my father before he passed away, and then to my mother. I had occupied one of the offices in that building. As Mr. Travis has explained, there are several offices in that building. Now, as I alluded to earlier, one of the things that I discovered in the operation of the child support program was that it was set up on an indirect billing program. That doesn't mean much to the people out there without knowing how it works, but what it meant was that the state was paying the county attorney rent on the county attorney's office. And I didn't think that was proper.
You mean on the office in the courthouse? Is that what you mean?
That was through a complicated billing procedure. That's what it amounted to. Now, that space there, doubling as both prosecutorial space and criminal and child support space, had people one on top of the other. It was, I'd say, less than approximately 200 square feet being shared with the prosecutorial staff. We were able to move that to Mrs. Rogers' building, triple the space, and not pay any more additional rent than was being paid through the indirect billing procedure. And if Mr. Travis has studied the child support system and how it works, he will understand that the county attorney pays the rent and the expenses under a direct billing process, and then is reimbursed a percentage of that. Now, the percentage that I was reimbursed was actually less than what the state was paying in what amounted to rent in the courthouse. So I believe if my opponent will study that, perhaps ask me for some records on that, we can show him how we were able to triple the space, save money, and have a system that has excelled.
Now, if I understand you correctly, and you correct me if I'm wrong, because I'm not sure that I do understand you, but you pay the rent that you're paying from the proceeds that you collect from the child support system. Is that correct?
No, sir. I'm responsible for the rent from my pocket. And whether that comes from the compensation I receive for operating the child support program or from my own personal funds, I am responsible for it. That is a part of my contract with the Commonwealth of Kentucky and the Cabinet for Human Resources.
In other words, and that's what I wanted to clarify, I
Yes,
don't
sir.
think you made that clear. You pay for the office rent out of what you get for your services from the contract with the state to collect the child support. Is that correct?
Well, no, sir. I receive compensation for running that program. Okay? Now, of course, I could use I could take that money, put it in my pocket, take it back out and pay that rent. It is not a procedure, it's not an organizational setup that says, pay the rent out of what we give you and then we pay you back, if that's what I'm understanding you to say. The rent is due from the person that operates the office. Then the state reimburses the person that has the contract to operate that program a percentage of what's paid. It's the same thing for salaries.
A percentage
also.
of the rent that's paid?
It's a percentage of the expenses and the rent. Now that percentage, at the rate of $300 a month, which is what it was when it began, was less than what the state was paying to have the office in the county attorney's office at a third of the space. And it simply has worked better on a direct billing process. And if my opponent will study that, he will see that, and perhaps he'll be interested in continuing that type of a program.
Mr. Travis, any
No,
comments?
sir. I will not be interested in continuing that type of a program. First of all, I own the building next door, and my totally monthly mortgage payment on it is $325 a month. And I rent 2,000 feet of that on the ground floor on the Main Street side and furnish utilities for $175 a month. And when I'm your county attorney, I'll be more than happy to provide the space at no rental expense to the child support office. I will not enter into such a ludicrous arrangement as this is. Now, Mr. Rogers says they were paying it before they were paying it for the courthouse. Well, who were they paying it to? They were paying it to Barren County, weren't they?
You won't care to answer the
Certainly.
question?
No, sir, they were not. Through the billing procedure that was in place at that time, the money would go to the county attorney. I might add that before entering into this direct billing arrangement with this different organization, different way of running the county attorney's child support office, we had an appraisal done to make sure that what we would be asking would not be out of line or out of way. A qualified appraiser appraised that at some $6 a square foot based upon rental at other places around the square. That was ludicrous. I knew it was ludicrous, and we didn't ask for $6 a square foot. It's some slightly over $2 a square foot. Now, because of the success of the child support program, we were able to expand the services, and we expanded the office space. We knocked a hole in the wall. We occupied additional office space, and in a 4-year period of time, the rent has increased by $75. Now, if you understand what I'm telling you about the way that the program operates, that was an increase in rent, but also an increase in expense to me. So the net effect of the way the program operates is, number one, no cost of Barren County taxpayer money through this tax commission money, 3 times the space it previously had, and additional staff because of the ability now to use the tax commission money to employ additional staff. I'm very proud of it. I want the people in Barren County to understand it. I know that there are some complicated issues in there. I would ask them to look at the results, and you can often judge a tree by its fruit, and I think the fruits of our tree have been bountiful.
I think I'm following you, but I'm still not sure about where the money is coming from that initially pays the rent. if I understand you correctly, that is your personal money. No tax money, nothing you've collected from the child support system. That is your personal money that you initially pay the rent with. Is that correct?
Absolutely, Mr. Barrickman. Just as the state could enter into a contract with a private individual, private attorney, if I refuse to carry out those duties, that person would be responsible for paying those. They would have no tax money to pay it from. And what I'm proud of is that we have been able to make that program stand on its own. No, we're not using tax money to pay rent. In fact, that child support program operates free and clear of Barren County taxpayer money now and operates on its own.
And then, based on what you collect, you get a percentage of the rent that you pay back from the state, plus other compensation in accordance with the contract, if I understand you.
Yes, sir.
Essentially.
Yes, sir.
Any other comments, Mr. Travis?
Well, this is most interesting, and it's difficult to attempt to really explain an impossible situation. And Mr. Rogers is in an impossible situation. He's literally between a rock and a hard place. And I'm amazed that he sits here and accuses the former county attorneys of using tax monies to fund the child support enforcement, because my understanding with both of his predecessors, they did not do that. They had to come up with their money to get the reimbursements the same way. But what he's doing, and if you look at the lease that he referred to, he had a lease with his mother, between his mother and himself with the Barren County Child Support Services for 1 year, from I think February of 90 through February of 91, for $300 a month. And of course this was obviously to milk that child support money for his own office. And then in 1991, or I believe it was, his wife, who is also employed in the child support office and on the state retirement system, I might add, sent a letter to the child support services saying that the owner, like it was some unknown third party from New York or someplace, had raised their rent to $375 a month, and she implied, well, we've got to pay that or we've got to move. And the people of Barren County, this was his own office. You know, who are they trying to fool with this kind of thing? They have milked the taxpayers too long on child support matters of this type and on cold check fees and Lord knows what else when you look.
Mr. Rogers, you've indicated that, if I understand you, that your personal income from the office, from all aspects of it, is in the neighborhood of $105,000 to $108,000. How much, if you got it in your head, how much income do you take in as a result of the office for all of the many duties that are attributed to the office? Of course, I understand a part goes to the state and a part goes to the county and well, even part to school boards and so forth, various taxing areas. But my question now is, do you have any idea of the total income that you take in as a result of your duties as county attorney?
Mr. Barrickman, we handle hundreds of thousands of dollars as county attorney. And no, I don't have that figure in my head to tell you precisely what it is, but it is hundreds of thousands of dollars. And I would, and stop me, and I know you will if you think it improper, but please allow me to respond just briefly to one thing that's been said.
Right, go right ahead.
The tax commission money that had previously been used in the operation of the county attorney's child support office, I'm not accusing anyone of breaking the law. I'm simply saying there is a more efficient way to do it, and we did it. And by doing that, with the same amounts of money, have been able to add additional staff.
May I try to answer your question since he refuses to? I can tell you that in 1992, his office was reimbursed $146,900 and something from child support, and he showed billed expenditures of $104,000. So you would assume that he has a net out of that of about $42,000, based on the figures that the Cabinet for Human Resources had. And out of that, those expenses, $104,000, he paid the $4,500 a month rent. And he also paid his wife a salary. I don't know what it was. He filed a CS-22 on her on May the 1st this year, saying her salary is over $12,000 a year, and that would be one of those billed expenditures. And what else, I don't know. I saw examples in their reports where they tried to buy picnic tables out of that money and various other things where the Cabinet rejected those claims.
One final question, and then I'm going to give each one of you about a minute and a half to tell why Mr. Travis, let him tell the public why he should be elected and why you should be retained. But of all of these revenues and so forth that are collected by your office, is your office audited?
All of the revenues collected are reported to the fiscal court. We tell the fiscal court every dollar, every penny that comes in. Now, the Child Support Office is audited through the state program. An audit of the Child Support Program is routinely scheduled for the end of this year, and be happy to show that to Mr. Travis when that comes through.
But there's no separate audit of the county attorney's office.
There's no audit of the cold check collection money, and perhaps that would be a good idea, if that's a suggestion. There's no audit of the escrow monies that we hold and the other monies, and that wouldn't be a bad idea. I wouldn't be opposed to that. The state has not done that, has not mandated it, but perhaps it'd be a good idea.
A minute and a half, Mr. Travis, why you should be elected county attorney of Barren County.
Because the people can trust me with their money, and the people can depend upon me to be a full-time county attorney for Barren County and attend to the duties, the constitutional and statutory duties of the Barren County attorney, and not spend my time off doing private practice of law or engaging in some other activity. Those are primary reasons. I'm well trained for it. You know, I've had a long experience in this, more years than I'd like to remember sometimes, and I started prosecuting cases and judging cases as a judge advocate in the Army back in the 50s, and I can do the job, and I can do it at less expense. I can save the county substantial money, and I will not take a penny out of that office for any fee in excess of the constitutional and statutory limitations.
Mr. Rogers.
Yes, thank you, Mr. Barrickman. You know, full-time county attorney has different meanings to different people. I often wonder what my opponent means when he says he will be a full-time county attorney, and I often wonder why he doesn't tell the people of Barren County that he also draws a retirement pension. I think those things are important. I have been a full-time county attorney, and all you have to do is look at the record to see that. Ask a neighbor if they've been to the county attorney's office and were able to sit down and talk with me and talk about a problem. Ask a single mother how Ben Rogers has protected her from the indignity of standing in the welfare line. There have been scores of people that we've been able to get off of welfare through that program. Ask a Barren County merchant what it has meant to have Ben Rogers handling the cold check protection and how we've expanded that program. You know, the county attorney has many responsibilities. We always look for a way to help Barren Countyans. And let me give you an example. Am I out of time?
I'm sorry. We've run out of time. Thank both of you gentlemen for appearing here tonight. I think it's been enlightening, and I think it's good for the citizens of the county to hear each one of you and your views about the office and why you should hold it. Thank you very much.
Thank you, sir.
See you, Ben. I hope so.
Our county attorney, Ben Rogers. 6 years working for you in the county attorney's office, which ranks in the top 20 in the state in child support collection. Ben Rogers, committed to prosecuting drunk drivers and working for business. Ben Rogers, on the job, working for you. Re-elect an experienced leader. Ben Rogers, a county attorney you can depend on.